Judgment in the appeal of Brown and another and Stonegale Limited.
Lord Reid will explain the decision of the court.
This case is concerned with 5 properties which belong to companies controlled by Mr Pelosi. One of the properties belonged to a company called Oceancrown. It had been valued at £762,000, but a developer had agreed with Mr Pelosi to pay £2.4 million for it. In order to sell the property to the developer, Mr Pelosi had to get the company's bank to agree to discharge a security which it held over the property. The debt to the bank was over £17 million. If the bank knew that the property was being sold for £2.4 million, it would insist on that money being paid to it so as to reduce the debt. And if the 4 other properties were sold, the bank would get the proceeds of those sales as well, as the bank held securities over all the properties and companies which owned them had guaranteed Oceancrown's debt. So as to avoid the value of all the properties going to the bank to reduce the debt, a scheme was devised. The way the scheme worked was this. The bank was told that the Oceancrown property was being sold, but that the price was not the £2.4 million actually agreed, but only the £762,000 at which the property had previously been valued. The bank was also told that the 4 other properties were being sold at prices totaling £1.7 million. That was untrue. The bank was told that the total of the sale prices, some £2.4 million, would be paid to it, and in return it was asked to discharge its securities over all 5 properties. The bank agreed. The Oceancrown property was then transferred to another of Mr Pelosi's companies at what was recorded as a price of £762,000, and on the same day that company sold it to the developer for £2.4 million. That money was then paid to the bank, but they were told that it was the proceeds of a sale of all 5 properties. The bank then discharged the securities over all 5 properties. The result was that the bank had been misled into releasing its security over 4 of the properties. Those properties were worth about £1.5 million. 3 of those properties were then given away to a company controlled by Mr Pelosi's son. The 4th was given to the son directly, and he then sold it for £125,000. Some months later, Oceancrown and the other companies in the group were put into administration by the bank. In these proceedings, the administrators have asked the court to set aside the transfers of the 3 properties now held by the son's companies and to order the son to pay them the £125,000 he received for the 4th property, under legislation designed to prevent assets being diverted away from a company's creditors. The legislation applies where there has been a gratuitous alienation or transfer. It is a defence to establish that the transfer was made for adequate consideration. That defence was rejected in this case by the lower courts, and appeals have now been brought to this court. The court unanimously dismisses the appeals. The appellant's argument has been put in different ways, but the transfers of the 4 properties were made in consideration of the discharge of their obligations to the bank, that the bank received the value of the properties when it was paid the £2.4 million, and that the administrators should have challenged the sale of the Oceancrown property to Mr Pelosi's company for the $700,000. The court sees no merit in any of these arguments. The position appears to the court to be very simple. Before the various transfers, the companies owned 5 properties. A bargain was in place for the sale of one of those properties for £2.4 million. After the sale was completed, £2.4 million was transferred to the bank in reduction of borrowings, and the companies retained the other 4 properties, valued at £1.5 million. Those properties were then conveyed to the son and his companies. The companies which had owned them received nothing whatsoever in return. There was no reciprocity between those disposals and the earlier payment made to the bank. The purpose and the effect of those transactions was to divert assets away from the creditors of Mr Pelosi's companies, exactly what the legislation is intended to prevent. The appeals are therefore dismissed.